Supreme Court has put a stop to parts of an effort by lawmakers to update the state's election code that would have given DAs, judges, and others a few extra years in office. News 13's Chris McKee explains.
Dean, the state Supreme Court determined today that parts of the new law are unconstitutional. House Bill 407, or the Election Law 50-year tune-up bill, passed the legislature and was signed by the governor earlier this year. But shortly after it took effect, 8 district attorneys filed suit against the state. The problem was the law sought to move all DA elections to 2022 when the governor gets elected. As a result, that law handed 8 DAs a special one-time 6-year term. Otero County DA John Sugg fought that change, noting that the state's constitution calls for DAs to only serve 4-year terms. Several of those DAs feared that any conviction they'd net in their 5th and 6th years in office would be thrown out.
None of us want to work hard to obtain justice, get a conviction, just to have it vacated because our election term got changed and we weren't properly in office. And so that's why the 8 of us joined together.
The state Supreme Court's ruling means that no term limits have been changed, and the 8 district attorneys that sued will all go up for election in 2020 as originally planned. Now, one of the lawmakers behind the bill told us tonight that the changes to the DA's term limits were simply a mistake. Any future changes to election years would likely have to come through a constitutional amendment. Dean.
All right, thanks, Chris. The Supreme Court also struck other changes from that law that sought to realign election years for magistrate judges and county officials in southeast New Mexico, and an effort to stagger election years for district court judges.